Courtrooms have a way of amplifying sound. Every cough echoes, every whisper carries, and every mistake lingers longer than the person making it expects. My uncle learned that the moment he leaned forward in his seat, turned toward me, and raised his voice. "You're ruined," Victor Langford shouted, loud enough for the entire gallery to hear. "After today, you won't have a cent left." The court clerk froze mid-typing. A few people in the benches shifted uncomfortably. The judge slowly lifted her eyes from the file in front of her. I didn't react. I didn't look at him. I didn't straighten my shoulders. I didn't give him the satisfaction of acknowledgement. Because Victor was wrong. I wasn't ruined. I was ready. The lawsuit itself was framed as a clean, respectable financial dispute. Victor Langford versus his niece. Alleged mismanagement of a family trust left behind by my grandmother. According to his filing, I had breached my fiduciary duty. I had diverted funds. I had concealed transactions. I had acted in bad faith. On paper, it sounded convincing. Victor was a senior partner at a regional accounting firm. Decades of experience. Tailored suits. A voice trained to sound reasonable even when it wasn't. I was 32. No spouse. No children. No prestigious title to flash in a courtroom. And Victor believed that imbalance alone would decide the case. His attorney delivered the opening argument with smooth confidence. Charts appeared on the screen behind him, carefully cropped timelines, and selectively framed numbers. They spoke about losses, about responsibility, about how family loyalty had been abused. Victor nodded along solemnly, his hands folded, his expression carefully calibrated to suggest disappointment rather than anger. When his attorney finished, Victor leaned back in his chair and glanced at me. "This will be quick," he murmured. I stayed still. When it was my turn, I stood slowly. I didn't rush. I didn't apologize. I didn't explain myself emotionally. "Your Honor," I said evenly. "Before addressing the allegations, I'd like to clarify the trust amendment history." Victor's attorney stiffened. "There is no amendment relevant to this case," he said quickly. I nodded once. "That's interesting," I replied, "because the amendment is the reason Mr. Langford no longer had authority over the trust." Victor's head snapped toward me. The judge raised a hand. "Proceed." I reached into my folder and removed a single sheet of paper. Not a binder. Not a stack. One document. I walked it to the clerk and returned to my seat. "This is the trust amendment dated March 11th, I continued. "It was executed in the presence of 2 witnesses and notarized by an independent attorney." Victor shifted in his chair. "It removes Victor Langford as co-trustee," I said calmly, "due to repeated unauthorized withdrawals and falsified expense classifications." The room went silent. Victor's attorney stood abruptly. "Objection. This document was never disclosed." "That's correct," I replied, "because Mr. Langford never filed it." The judge turned to Victor. "Is this your signature?" Victor hesitated, then nodded. "Yes," he said tightly, "but the funds she's accused of mismanaging were handled after your removal," I said, my voice level. "Which means you no longer had legal access to the trust at that time." I could feel the shift in the room. This was no longer about my competence. It was about his credibility. "And Your Honor," I added, "the transactions described as losses were reimbursements. The funds were returned to the trust after being improperly withdrawn." I paused. "And I can show exactly where they went?" I reached into my folder again. This time, the paper carried weight. The clerk's eyebrows lifted as she scanned it. The judge leaned forward. "Mr. Langford," the judge said slowly, "these withdrawals were transferred to an account bearing your name." Victor stood halfway out of his seat. "That's impossible," he snapped. "She's lying." I didn't respond. The document already had. The judge turned to his attorney. "Why was the court not informed that your client had been removed as trustee prior to these transactions?" There was no immediate answer. Victor's confidence evaporated. The man who had shouted that I was ruined now looked like someone realizing he had misjudged the room. And we hadn't even reached the document that would finish it. The judge didn't raise her voice. She didn't scold. She didn't even look surprised. She simply leaned back in her chair and folded her hands. "Mr. Langford," she said, "you will remain seated." Victor obeyed. but the confidence that had filled his posture minutes earlier was gone. His shoulders were tense now, his jaw tight, his eyes no longer scanning the room like he owned it, but flicking between the bench, his attorney, and the documents in the clerk's hands. The judge turned to me. "Continue." I nodded once. "The amendment removing Mr. Langford as co-trustee was executed after my grandmother discovered multiple discrepancies in her monthly statements," I said. "Those discrepancies were documented, the findings were reviewed by her estate attorney, and the decision was made quietly." Victor's attorney cleared his throat. "Your Honor, even if this amendment exists, it does not prove intentional wrongdoing." "That's correct," the judge replied, "which is why I'm listening." I reached into my folder again. This time I didn't stand. I didn't walk. I simply placed the document on the table in front of me and slid it forward. "This," I said, "is the internal audit my grandmother commissioned 6 weeks before she passed." Victor's head lifted sharply. The judge reviewed the header, then flipped the page. The room felt heavier, the kind of silence that settles when everyone senses the floor shifting under someone else. The audit was thorough. Dates, amounts, cross-referenced entries, withdrawals categorized as administrative expenses that had no corresponding invoices, transfers routed through a holding account Victor controlled personally. "These transactions," I continued, "are the same ones my uncle now claims I mismanaged." Victor's attorney stood again. "Your Honor, my client has not been charged with any wrongdoing." The judge looked up. "No one has said he has. Sit down." Victor's attorney sat. Victor didn't look at me anymore. He stared straight ahead, his lips pressed into a thin line. I kept my tone steady. "When my grandmother passed, I followed the instructions outlined in the amendment. I restored the funds to the trust. Every transfer is documented, every movement accounted for." I paused. "The only reason these reimbursements appear suspicious is because the initial withdrawals were never disclosed." The judge closed the file slowly. "Mr. Langford," she said, "did you inform the court that your removal as trustee was based on suspected misuse of trust funds?" Victor opened his mouth, closed it, then shook his head once. "No," he said quietly. The judge nodded. "That omission is noted." Victor's earlier outburst echoed faintly in the room now, stripped of its power. "You're ruined." He hadn't been speaking to me. He had been projecting. The judge turned to his attorney. "Counsel, I want to be very clear. This court does not look favorably on selective disclosure." Victor's attorney swallowed. "Understood, Your Honor." The judge shifted her gaze back to me. "Is there anything else you wish to submit?" "Yes," I said. And for the first time since the trial began, Victor looked at me with something close to fear. I stood again and removed the final document from my folder. "This," I said, "is the email correspondence between Mr. Langford and the bank that held the trust's operating account." Victor's attorney tensed. "It shows," I continued, "that 2 weeks after his removal as trustee, Mr. Langford attempted to initiate a wire transfer using outdated authorization credentials." The judge's eyes narrowed. "He no longer had signing authority," I said. "The bank flagged the request and declined it." I paused. "And that," I added, "is when this lawsuit was filed." The judge leaned back. "So," she said slowly, "this action was initiated after your attempt to access funds was denied." Victor's breathing was shallow now. Fast. His attorney leaned toward him, whispering urgently. Victor didn't respond. The judge exhaled through her nose. "I've heard enough for today." She picked up her gavel. "This claim is dismissed." The sound of the gavel striking wood was sharp. Final. Victor's shoulders slumped. But the judge wasn't finished. "Additionally," she said, "the court is referring this matter to the appropriate authorities for review of the audit findings and the attempted unauthorized transfer." Victor's head snapped up. "Your Honor." "Court is adjourned," she said, bringing the gavel down again. Victor didn't speak after that. He just sat there staring at the table, while his attorney packed up in tense silence. I gathered my documents calmly, methodically. As I turned to leave, I felt Victor's eyes on my back. He didn't shout this time. He didn't threaten. He didn't say anything at all. And that silence told me more than his earlier outburst ever could. Because confidence is loud, But accountability is final. Most people think the moment the gavel falls is the end. It isn't. It's the beginning of consequences. Victor didn't move when the courtroom began to empty. He remained seated, staring at the polished wood of the counsel table as though it might offer him an alternate outcome. His attorney leaned toward him again. "We need to leave," he whispered. Victor stood slowly. He no longer looked like the senior partner who had walked into that courtroom with rehearsed outrage and calculated superiority. He looked smaller, human, exposed. I placed my documents back into my folder in the same order I had removed them: amendment, audit, bank correspondence. I didn't rush. There was no reason to. As I turned toward the aisle, Victor finally spoke. "You think this is over?" he asked quietly. His voice had lost its projection. It no longer reached the gallery. It barely carried to me. "It is," I replied evenly. "For me?" He swallowed. "For you," he repeated almost to himself. The bailiff approached the bench, speaking softly to the judge. I didn't need to hear the words to understand what was happening. A formal referral meant documentation. Documentation meant review. And review meant scrutiny. Victor had built his entire professional identity on being the one who examined numbers. Now the numbers would examine him. I walked past him without slowing. The courthouse hallway felt colder than the courtroom. Fluorescent lights hummed overhead. Footsteps echoed against the stone floor. Behind me, I could hear Victor arguing quietly with his attorney. "This was her plan," he said. "She set this up." "No. I documented it. There's a difference." Outside, the air was sharp and clean. I descended the courthouse steps slowly, the city noise returning in measured waves, traffic, distant sirens, the rhythm of ordinary life continuing, indifferent to courtroom outcomes. My phone vibrated in my hand. Unknown number. I answered. "Ms. Langford?" a voice asked. "Yes. This is Investigator Hale with the Financial Compliance Division. We've received the court's referral and would like to schedule a formal statement regarding the audit findings." "Of course," I said calmly. "We'll also need any supporting documentation you referenced today." "You'll have it," I replied. The call ended. Victor had believed the courtroom was the battlefield. He hadn't understood that it was only the first layer. I reached my car and placed the folder carefully on the passenger seat. Inside were copies of everything, but not the originals. Those were already secured. Victor underestimated something fundamental. He assumed that because I was younger, quieter, and less visibly authoritative, I would respond emotionally, that I would argue, that I would defend myself defensively. Instead, I waited, I collected, I verified, and I let him file the lawsuit, because once he did, discovery became inevitable, and once discovery began, paper replaced performance. Later that afternoon, an email arrived from the accounting firm where Victor had worked for 28 years. Subject line: Internal review notification. The message was brief. Due to recent court disclosures, Mr. Victor Langford has been placed on administrative leave pending investigation. Professional reputations are fragile things. They don't collapse because someone shouts in a courtroom. They collapse because someone prints the ledger. That evening, Victor called. I let it ring once, twice, 3 times. Then I answered. His voice was stripped of arrogance now. "This didn't have to go this far," he said. "Yes," I replied. "It did. You could have handled this privately." "You filed the lawsuit," I said calmly. "You accused me publicly." Silence. "I was protecting the family," he said weakly. "No," I corrected. "You were protecting yourself." Another silence. Then the line went dead. There's a moment when someone realizes they've lost control of a narrative they thought they owned. That moment had arrived for Victor long before the gavel struck. He just didn't recognize it until the paperwork surfaced. I never needed to raise my voice. I never needed to threaten. I never needed to retaliate. All I had to do was keep records, because intimidation fades, but documentation endures. And when someone stands in a courtroom and declares you ruined, the only response that matters is the one printed in black ink beneath their own signature. 2 days after the dismissal, the story stopped being private. At 7:12 a.m., I received a notification from the state licensing board. Victor's CPA credentials had been placed under temporary review pending investigation into material non-disclosure and fiduciary irregularities. By 8:03 a.m., the accounting firm removed his profile from their website. By 9:30 a.m., he called again. I didn't answer. Instead, I opened my laptop and began compiling a supplemental file for Investigator Hale. If this was going to widen, and I knew it would, then I intended to control the pacing. Victor had relied on intimidation in a courtroom. Now he would have to rely on memory under oath, and memory is unreliable when documentation exists. At 11:17 a.m., a courier delivered an envelope to my door. No return address. Inside was a single sheet of paper, a photocopy of my grandmother's final handwritten note, the one she dictated 6 weeks before her death, the one referencing family harmony. At the bottom, in blue ink, Victor had circled one line and written 3 words beside it. You betrayed her. I stared at it for a long moment. This was his pattern. When numbers failed, he pivoted to guilt. When logic cornered him, he weaponized emotion. But guilt only works when facts are uncertain, and the facts were no longer uncertain. That afternoon, Investigator Hale called again. We've reviewed the audit summary, he said. There's something you didn't mention in court. I assumed you'd find it, I replied. A pause. The holding account, he said. It wasn't solely in Mr. Langford's name. No, I said evenly. It wasn't. It was a joint account. Yes. With whom? With a Shell LLC, registered 3 months before the unauthorized withdrawals began. Another pause. And who controls that LLC? He asked. Victor does, I said. Through a nominee officer. Silence. You're very thorough, Hale finally said. I learned from watching him, I replied. What I hadn't said in court, what I had deliberately withheld, was that Victor's misappropriation wasn't impulsive. It was structured. The Shell entity had a neutral name. Harmless, administrative. It was designed to receive consulting transfers. But consulting transfers require contracts. There were none. By 4 p.m., Investigator Hale requested a formal in-person statement. I agreed. That evening, Victor showed up at my building. He didn't call ahead. He didn't announce himself. He was simply there when I stepped out of the elevator, standing near the lobby's glass doors. He looked exhausted. Not angry, not indignant. Just cornered. We need to talk, he said. We don't, I replied. This is spiraling, he said. They're auditing everything. 28 years of work. You filed the lawsuit, I reminded him. You forced my hand. No, I said calmly. The bank did. He flinched. That detail still unsettled him. He stepped closer, lowering his voice. You think this ends with me? He asked. You think regulators stop at one name? There it was. The first crack. The suggestion that he wasn't alone. I didn't respond immediately, because sometimes silence invites more truth than confrontation. They'll start digging into the trust's original structure, he continued, into decisions your grandmother made long before you were involved. I welcome that, I said. His jaw tightened. You're naive. No, I replied. I'm documented. He stared at me for several seconds. Then he did something unexpected. He reached into his coat pocket and pulled out a small flash drive. He held it between 2 fingers. If this goes forward, he said, you'll want to see what's on this. I didn't reach for it. What is it? I asked. Insurance, he said quietly. Victor had always believed leverage was protection. Even now, facing professional collapse, he was bargaining. With what? I asked. He hesitated. With things your grandmother didn't tell you. The air in the lobby felt heavier. That was the first time doubt attempted to surface. Not about the numbers, but about the narrative. You're bluffing, I said. He shook his head. Take it, he said, before someone else does. The doors opened behind him as another resident entered. Victor stepped aside automatically, momentarily displaced by ordinary life. When the doors closed again, he was still holding the flash drive, but his hand had lowered slightly. Give it to your investigator, he said, or keep pretending this is simple. He placed it on the marble console near the mailboxes and walked out without another word. I didn't move for several seconds. Then I picked it up. It was unmarked, lightweight, silent. Victor had just escalated this from misappropriation to something deeper, something historical. And if there's one rule I follow, it's this: never accept leverage without verifying its origin. I went upstairs, locked my door, and opened my laptop. Because if Victor thought the courtroom was loud, he had just introduced a file that might be louder. I did not plug the flash drive into my personal laptop. That would have been careless. Instead, I retrieved an old machine from the back of my closet, one that had never touched my primary accounts, never logged into my email, never synced to cloud storage. I powered it on, waited for the system to stabilize, then connected the drive. 3 folders appeared. One was labeled tax. One was labeled trust. The third was labeled simply correspondence. Victor had never been subtle. I opened correspondence first. Inside were scanned emails, PDFs, and letters dating back nearly 12 years. Long before my grandmother amended the trust. Long before she removed Victor. Long before I was even involved. The first email was between Victor and a private wealth advisor. Subject line: temporary structuring. The language was polished, professional, but the intent was unmistakable. Victor had been parking funds, moving them through interim accounts, returning them later, all without disclosure. Not theft in the crude sense. Manipulation, optimization, control. My grandmother's responses appeared lower in the thread, shorter, sharper, increasingly concerned. The final email from her was dated 6 weeks before the amendment. I want everything documented, effective immediately. Victor never replied. I leaned back in my chair. This wasn't leverage. This was confession. The trust folder was worse. Internal memos, unsigned contracts, expense classifications that never matched reality. And then I saw it. A scanned letter bearing my grandmother's signature, but not written by her. The language was wrong, the cadence off, the phrasing corporate, not personal. Victor had drafted it, printed it, had her sign it during a period when her medical records I already possessed, clearly indicated diminished capacity. He had used it to justify continued control. I closed the file. Victor hadn't just mismanaged funds. He had exploited decline. At 9:04 a.m., the next morning, I forwarded a single email to Investigator Hale. Subject line: supplemental evidence, priority review. No commentary, no accusations, just files. At 9:27 a.m., he called. Ms. Langford, he said carefully. Where did you obtain this material? From Mr. Langford himself, I replied. Silence. He delivered it voluntarily? Yes. Another pause. This significantly broadens the scope, Hale said. I assumed it would. We'll need to move quickly. I'm available, I said. The call ended. By noon, Victor's firm issued a second internal notice. This one was not administrative leave. This one was termination, effective immediately. Licenses pending revocation. Compliance review expanded. Victor's professional life collapsed quietly, without spectacle. No shouting, no courtroom drama, just email subject lines and locked accounts. That afternoon, Victor called again. I answered. You gave them everything, he said. His voice was hollow now. You gave it to me, I replied. I thought you'd be smart enough to negotiate. I am, I said calmly, with facts. You don't understand what you've done, he said. I understand exactly, I replied. You assumed silence meant ignorance. His breathing was uneven. They're asking about things from years ago, he said. Things that don't matter anymore. They mattered enough to hide, I said. He laughed weakly. You think this makes you righteous? No, I said. It makes me accurate. The line went dead. 3 days later, I was subpoenaed. Not as a defendant, as a witness. Victor was no longer suing me. Victor was being investigated. The irony was almost surgical. He had dragged me into court to destroy my credibility. Instead, he had triggered a process that dismantled his own. When I arrived at the federal building for my statement, I passed Victor in the lobby. He looked older, smaller. He didn't speak. Neither did I. There was nothing left to say. People often ask what justice feels like. They expect relief, triumph, closure. But justice, real justice, feels procedural. It feels like forms, like timestamps, like signatures that finally line up with reality. Victor screamed that I was ruined. What he didn't understand was this. The moment he raised his voice, he lost control of the facts. And facts don't care how confident you sound. They only care that you kept them. Federal buildings are quieter than courthouses. There is no gallery, no murmuring audience, no dramatic outbursts, just fluorescent lights, recorded statements, and the soft click of a pen when someone finishes answering a question. I was sworn in at 10:02 a.m. Investigator Hale sat across from me with a thin recorder positioned between us. 2 additional officials were present, one from financial compliance, one from professional licensing. The questions were precise. When did you first suspect irregularities? How were the reimbursements calculated? Did you confront Mr. Langford prior to litigation? I answered each one evenly. I never speculated. I never dramatized. I never guessed. When I didn't know something, I said so. When I did, I referenced documentation. The difference between accusation and evidence is composure. At 11:37 a.m., Hale slid a document across the table. Is this your grandmother's signature? He asked. I examined it carefully. Yes, I said. But the language is not hers. He watched my face as I spoke. How can you tell? She didn't use that phrasing, I replied. And the medical records from that month indicate cognitive impairment. The licensing officer made a note. Did Mr. Langford draft this document? She asked. I believe so, I said. The metadata from the file matches his office system. There it was again. Metadata. Victor had underestimated timestamps. He had underestimated authorship traces. He had underestimated how permanent digital fingerprints are. By noon, my statement was complete. As I gathered my folder, Hale spoke again. There's something else, he said. I paused. The Shell LLC, he continued. We traced its formation documents. And, I asked, it was registered by a paralegal at your uncle's firm. That didn't surprise me. Was she aware of its purpose? I asked. Hale's expression didn't change. We're still determining that. Victor's world was shrinking, not loudly, but methodically. 2 weeks later, the formal notice arrived. The state accounting board suspended Victor's license pending permanent revocation. Simultaneously, the U.S. Attorney's Office opened a formal inquiry into fiduciary misconduct and financial misrepresentation. No handcuffs, no flashing lights, no public spectacle, just letters, official seals, deadlines. Victor called once more after the suspension. His voice was thinner now. They're talking about intent, he said, about deliberate structuring. Yes, I replied. You knew this would escalate. I knew the documents would be reviewed. You could have stopped after the dismissal, he said quietly. I didn't escalate, I answered. You did when you filed the suit. Silence lingered between us. I was trying to fix a mistake, he said. No, I corrected. You were trying to erase exposure. Another silence. Do you feel satisfied? He asked. The question wasn't angry. It was tired. No, I said honestly. That seemed to surprise him. You don't? No, I replied. I feel resolved. There is a difference. Satisfaction is emotional. Resolution is structural. One fades, the other holds. Months passed. The investigation deepened. Victor's former firm settled with regulators to avoid broader liability. The Shell LLC was dissolved. The holding accounts were audited. The trust, my grandmother's trust, was stabilized permanently under court supervision, exactly as she intended in her final amendment. One afternoon, I received a certified letter. Victor had agreed to surrender his license voluntarily in exchange for a reduced penalty. No admission of guilt, but no denial either. Professional exile without courtroom theatrics? The man who once commanded boardrooms would never practice again. And not because I shouted back, because I kept records. The last time I saw Victor was outside the licensing office downtown. He was exiting as I was entering to finalize compliance paperwork. He paused when he saw me. For a moment, neither of us spoke. You were always quieter than I expected, he said finally. Yes, I replied. I mistook that for weakness. I know. He studied me for a second longer. Then he nodded once. No apology, no bitterness, just acknowledgement. And then he walked away. When people remember the story, they remember the shout. You're ruined. They remember the drama, the courtroom, the accusation. What they don't see is the preparation, the timestamps, the archived emails, the amendment filed months before the lawsuit. Victor believed volume created authority. He believed intimidation replaced accuracy. He believed that if he said it loudly enough in a courtroom, it would become true. But truth doesn't respond to volume. It responds to verification. And when someone screams that you're finished, the only answer that matters is the one printed beneath their signature.